I might answer how you. So. Here. All right.
Be seated. I'm going to call on record, this is People of the State of Illinois versus Austin, Rodhouse, 24 CF 58. Mr. Rodhouse appears in person in custody of the Pike County Sheriff's Department. Ms. Schnacht appears on behalf of the defendant. Ms. Carnes and Mr. Filbert appear on behalf of the people. The matter is convened today for sentencing. The court did receive the pre-sentence investigation report and all attachments thereto. I have reviewed the same and I am ready to proceed. Ms. Schnacht, did you and your client receive that report, and are you ready to proceed?
Your Honor, I received the report. Mr. Rodhouse received the report. We have both had the opportunity to review the same and ready to proceed with sentencing.
Ms. Carnes, did people receive that report, and are you ready to proceed?
Yes, Judge.
Is the state aware of any additions, corrections, or deletions to be made?
Judge, I do have in particular an addition, which is the victim impact statement, and I do have that. I know I emailed it to the defense and judge yesterday, but I do have a signed version of that now. You have the original in your hand, and a printed copy has been provided.
Ms. Schnapp agrees the court should not receive the victim impact statement.
No, Your Honor, I did receive that from Ms. Carnes ahead of today.
And the court will receive that and review that. Any other additions, corrections, or deletions to be made, Ms. Carnes?
The days he's been in custody, obviously they do it when they're doing it, but it's 260 days as of today.
That's my note. That would count May 8th, 2024 through December 31st, 2024, and then 22 days in the month of January is 260, and that's the notation I made as well.
As far as corrections, I don't have what I would call corrections. I have some arguments, and I have an evaluation from 2015 in a file that's up here that I'll probably ask the court to take judicial notice of certain parts, only the social history parts of it, that where the defendant self-reported in that evaluation significantly different information than he self-reported in the PSI evaluation.
And
I did have,
Ms. Carnes, I mean, just so we're clear, in order to get to the point where you get the opportunity to argue as to the contents of the PSI and what should be done here today, as far as the contents of this file or the court's records that you may be asking me to take judicial notice of, those are the contents of the file referenced in the PSI 14C and 17.
correct.
And what are you asking for me to look at specifically?
Well, I'm not, so there's a sex offender evaluation from that case, and I'm not asking you to read the whole thing. I'm going to point out certain parts where there's like social history part, and point out the differences in what he reported at that time compared to now.
Ms. Schnock, I believe I have the ability to take judicial notice of my own records, and specifically that pertaining to a case that is referenced in the PSI, as to what the state is suggesting you wish to be heard.
Your Honor, I agree that the court does have the authority to take judicial notice of the court file. However, I think taking a sex offender evaluation that is nearly 10 years old for today's purposes would be inherently prejudicial, inherently unfair, given the fact that the maker of that report isn't here, hasn't been considered or discussed with probation. That evaluation was done for a completely different purpose other than for today's purposes. And the relevance, as far as sentencing, I have concerns that it would be highly irrelevant given the factors that the court is allowed to consider in aggravation and mitigation, and given the fact that we are all, to a certain extent, hamstrung by mandatory sentencing guidelines. I'm not sure how that would be helpful to the court in fashioning a sentence for Mr. Rodhouse, especially if you're only taking bits and pieces of a 10-year-old report that was made for purposes other than today's sentencing.
I will take it back for your last word on that point, Ms. Carnes.
Well,
But before I do that, let me just say also, in advance of today's proceedings, I did not order a sex offender evaluation to be done. The reason being is that these are the majority of the offenses for which he's being sentenced today are mandatory Department of Corrections sentences, where these carry natural life sentences, and a sex offender evaluation in a case such as this would only be required in the event probation was authorized. That is not the case here, and so I did not see fit to order it. That would not be required in this instance. Ms. Carnes, as far as the last word on
Judge,
what you want me to do here.
because I knew that we couldn't order a sex offender evaluation for our case, that's why I didn't even ask to submit this. And that's also why I'm asking for you not to look at the part that has to do with the specific facts of that case and what the findings were of the person who made that evaluation. I'm looking only at these things that are about what he reported at that time. And while I do know we've got 4 counts that have a very serious mandatory sentence, we have a lot of other counts that don't. And I think I still get to argue for what I believe a proper sentence should be on those. And that part of that argument is this court, these people, these victims have dealt with a man who is a huge liar, and he uses his lies to manipulate people, and this is what he's done his whole life.
The court's considered the arguments with respect to this point. I have fairly broad discretion as to what I can consider at sentencing purposes and for what I'm hearing here that the state is wanting to offer or for me to take notice of via a limited portion of the evaluation. I believe that it would be admissible, or the court can properly consider that, and I will. As far as the weight that I will give that for purposes of today's proceedings, articulate that once I see it. But I will allow the state to present that for my review.
And I will get to that. I have a couple of witnesses I want to put on.
We're not there yet.
Okay.
Now, any other additions to be made?
No.
Ms. Schnock, on the part of the defense, other than the correction for the credits or time served, are there any other additions, corrections, or deletions to be made?
No, Your Honor.
Thank you. Ms. Carnes, evidence and aggravation.
Yes, Judge, I have a couple of witnesses.
Who do you wish to call?
I would like to call Jordan Gerard first.
Jordan Gerard, come forward, please. Please take the witness chair. Mr. Cards, you may inquire.
Thank you. Will you please state your name for the record?
Jordan Gerard.
And what is your occupation?
I'm a special agent with the Illinois State Police.
And I'm sure many of us are aware, but what was your role in this case?
I was the primary case agent.
And who was your partner?
Eric Glass.
As part of this case, we're aware there's 2 minor victims, correct?
Correct.
And at the time this case began, they were 3 and 4. Is that correct?
Correct.
Were interviews at the Child Advocacy Center conducted of those children?
Yes, they were.
And were you present to observe those?
Yes, I was.
Where were you in comparison to the children when you were observing those?
So during a child advocacy interview, the interview takes place in a separate room from where law enforcement and other investigators are located. And I was in that room watching the interview on a live TV screen with sound.
And do you recall when the children are brought there, were they brought by family?
Yes.
Okay. And do they stay with their family in a separate room while one child's interviewed?
Yes.
Were you able to hear them down the hall while they were in that room separately, like having fun, playing games?
Yes.
Okay. And then when a child would be interviewed, do you remember who went first? Okay. And does he go into a room with just the person who's going to interview him?
Yes.
Okay. In that room, are there cameras?
Yes.
And in this particular situation, were the cameras pointed out?
They were not.
Or at least at the beginning?
They were not.
Okay. And do you remember if that was a kind of a strategic decision that was made because of the factual circumstances in this case?
Yes. I looked up and seen the cameras, and his demeanor changed. He became more closed off. Once investigators noticed that, we advised him that it is recorded for our purposes, so we can go back and look at it, and that we are the only ones that can view that today. There was nobody else there.
What was the relevancy of seeing the camera at the CAC to what had been going on in their home life?
They had cameras in their home, and the boys mentioned in a CAC interview of having cameras at their house and being watched.
And did he mention who watched them on the camera?
His dad.
And you said when he did notice there was a camera there and his demeanor changed.
Correct.
Was he talkative before that?
He was.
And did he become untalkative after that?
Yes, to the point that there was a couch in there. He went and positioned himself on the far end of the couch where it would be hard to be, or less of his body to be seen by the camera.
And we could still see him cracked, but he maybe thought he was hidden.
Correct.
And in those interviews, the children, just in general, all children are kind of asked about their family members, correct?
Correct.
And in regards to his family members, did he express fear of any particular family member?
His father.
And we would be referring to his father as Austin Rodhouse, correct?
That is correct.
And I want to move on to interview. Was he interviewed after?
He was.
Prior to going into the interview room, could you hear him as he came down the hallway?
Yes,
Was he talkative?
he was.
And what did you observe as you went into the room from your perspective in the other room?
Well, he noticed the cameras that were in there, and he was open for a while, kind of talking, but he was not opening up fully. So investigators asked the interviewer if they would go in and let him know that the cameras are there, why the cameras are there, and then we took him around the whole building to show him, if there was nobody here to do him any harm whatsoever, to make him feel more comfortable.
Did he express who he thought was in the building watching him?
His father, Austin.
And again, when it came to talking about the family, did he express who he had fear of in his family, if anyone?
A lot of the times it was inaudible there, so some of
Okay.
the stuff you couldn't hear on him that must be the question was asked.
Okay. But when they walked him around the building and opened up, were they opening every door?
Yes.
And was that so he could see if his father was in any of the rooms?
Yes.
Did either of the boys express any of that same fear when it came to their mother or any other family members?
I think one of the boys misspoke. He said he was in fear of his pawpaw, but I'm not sure what he was meaning by that exactly.
Okay. I mean, he was actually with his papa and they seemed fine, right?
They seemed very good.
Okay. Only other thing I wanted, a couple things actually. In regards to interviewing, did you interview pretty much everybody in Austin's family?
Either myself or another state police investigator did, yes.
And in regards to what they had to say, I want one specific thing. Austin has reported he was enlisted in the military for 3 years. In regards to every one of those family members, what is the one thing they told you he does that was not true?
Objection, Your Honor.
What's the basis of your objection?
You're saying
I would agree that it does call for a hearsay response, but hearsay can be admissible in the sentencing hearing, and if you can respond to the question, you may do so. The objection's overruled.
Yeah, would you ask one more time, please?
Well, in regards to all those family members, like what is the one thing they all agreed on that he does? I'll be specific, that he will say in regards to the military.
That he was in the military, but in all actuality, he was not in the military.
And that the only thing he ever did was basic training in between his junior and senior year.
Yeah, he went through the ROTC program and went through whatever training that's on.
Okay. I have no further questions.
Cross-examination.
Oh, no, I'm sorry. I forgot. One quick thing. In June of this 2024, you needed to interview his grandma, Julie, about a certain situation, correct?
That is correct.
And that took place at the jail here in Pittsfield, right?
Correct, by County Sheriff's Office.
And was that you and Chas Anderson did that one together?
Yes.
I just want to show you what I've marked as People's Exhibit, the Sentencing Exhibit 1. Do you recognize this?
I do.
Have you watched the contents of this already?
I have.
And does it fairly accurately depict a very short section of that interview on that day?
It does.
Judge, I would ask to admit and publish this. It's about 10 seconds.
Ms. Schnott, do you wish to be heard or object?
I'll object for the record, Your Honor.
Your objection is noted for the record, but as indicated earlier, I believe I can consider this for purposes of sentencing, and will do so. Objections overruled.
Oh, it should. I have enough over there. Sorry, they powered down. I'm so sorry. I have to open it.
And I can tell you, on and often, we do not take anything they say for real. Nothing. They both make
Where's the mom? Oh, what's it on? Well, my laptop's showing. Oh, it's showing up. It's doing the Zoom piece here. It should be lovely. Is it plugged in over there and turned on? They sound like well, I can just play the sound, play it again with just the sound. Judge, I'm just going to play it again with the sound. Make
You
sure
may do so.
I can tell you, often and often, we do not take anything they say for real. Nothing. If they both make things up, they both exaggerate things. So,
And that was it. No, I don't have any further questions. Sorry about that.
You concluded your correct
Correct.
cross-examination, Ms. Schnuck.
During your observations of the boys, did you notice any outward signs of abuse?
I didn't notice any signs of physical abuse on them. With what I observed with, skin or any bruising like that, the answer is no.
Okay. And did they give appropriate answers to the questions that were posed to them based upon their relative ages?
Once I observed the camera, they became very closed off in their answers, which is abnormal for most kids.
And I guess I should clarify my question. Did either one of them appear to have any intellectual delays that would make the investigators think that maybe they didn't understand the questions that were being asked?
No.
Okay. No other questions, Judge?
Redirect.
No, Judge.
Thank you. You may step down.
Thank you.
Judge, I'm
Additional evidence and aggravation or other witnesses at this time is going to...
Yes, Judge, I want to call Jessica Fuller real quick.
Jessica Fuller, come forward, please, and stand before the bench and be sworn.
Testimony doesn't give the truth, the whole truth, and nothing but the truth, so be God here.
Please stick to this chair. Ms. Carnes, remain quiet.
Can you please state your name for the record?
Jessica Fuller,
How are you employed?
Chat Foster and Adoption.
And what specifically do you do at Chaddock?
I am a child welfare specialist.
And I don't think it's a secret at this point. The two boys went into foster care at the beginning of this case, correct?
They are currently in foster care, yes.
Are you the caseworker on those cases?
I am.
Were you assigned to be the caseworker at the very beginning?
I was.
And at that time you first got assigned, were you aware that their father was in jail and their mother was currently in the hospital?
Yes, ma'am.
And their mom actually ended up being in the hospital approximately 10 days, correct?
That is correct.
After she, and correct me if I'm wrong, but while she was in the hospital, which started May 7th, did her children have any contact with her during that time?
No.
Once she had gotten out, did you set up for her to have a supervised in-person 2-hour visit with the boys?
I did.
Do you recall what day that ended up being?
It was May 24th, 2024.
So at this point, she had gone into the hospital May 7th and has not seen her children up until that day or had any communication with them, correct?
That is correct.
Okay. And how many times did you drive the boys to that supervised visit?
I did.
How many times before you drove them to that visit had you seen those boys before?
One time.
Okay, so you're pretty much a stranger, correct?
Correct.
When you arrived at wherever this visit was, when you first arrived there and they saw their mother, how did those two boys react?
They were very excited to see Miss Cromis.
And just during the course of the 2 hours, not going into a lot of detail, but how did it go?
It went well. Miss Cromis came prepared. Her mother was with her. Susie, Deborah Cromis, but they call her Susie. They came prepared with snacks, drinks, toys. There was a lot of, I could feel relief in the room, a lot of excitement, a lot of hugs. It went well. The visit went well.
Okay. And then at some point it has to end, right?
That is correct.
How did that go?
It was a little difficult, a little rough. There were lots of hugs, some tears, but we managed.
Okay. And then were you responsible for driving the boys back to their placement?
I was.
When you drove them back, did he say something to you about his mother?
He did.
What did he say?
He said, "Did someone save my mommy?"
And what did you say?
Yes. Someone saved your mommy.
I don't have any further questions.
Prior to this occasion, DCFS had never investigated Austin before, is that correct?
He has in juvenile, but not him personally.
So this was the first time DCFS had ever investigated him as an adult for child abuse or neglect?
Yes, ma'am.
And when he was a juvenile, was he ever brought into DCFS care?
No, ma'am.
And when the boys were originally brought into foster care, they were placed with Austin's grandfather, Rick Rodhouse, correct?
And his wife, Sean, yes.
And eventually that was changed, and they were eventually placed with...
I'm going to object. Going beyond the scope.
Overruled.
And eventually they were placed with parents, correct?
Yes, ma'am.
Was there a reason that their placement was changed when it was?
I am going to object to that. That's a confidential juvenile file.
She brought all of this up, Your Honor. The door's been brought, is open.
The only thing I was going towards is the impact. This is about impact on the victims and their victims. I'm not sure where we go into getting into a confidential juvenile file about everything that's happened in that case.
Well, it's a big part of the record that they're in foster care right now. So what's confidential, Ms. Carnes?
Well, I would say service plans,
I'm not asking about
ratings,
Yeah.
changing, and why
Okay.
changing.
Well, your objection's noted, but we'll overrule the objection. Do you need to re-ask the question, or do you understand?
No,
what
the placement was moved. Ms. Cromis had spoken about her intent to stay in Ohio. At that point, Mr. Rodhouse was in jail. There was a order where he was to have no contact with the children. She was in Ohio, and so we got a court order regulation 7 expedited interstate compact in order to move the children to Ohio where she could have reasonable visitation with her children, as she was the only permanency option at that time.
So it was a move out of convenience as opposed to availability of services in Ohio?
I'm not sure I understand what you mean as far as availability of services.
Well, was the move from Pike County or Calhoun County, Illinois to Ohio, was that purely out of convenience to set up visits between the boys? Or were there other ancillary reasons like lack of resources for her and the boys here compared to Ohio?
There wasn't a lack of resources here versus there. No, that's not what it was about.
Okay. And when you were driving the boys for the first visit, did you tell them where they were going and why they were going there?
Yes.
Okay. And do you remember exactly what it was that you told them?
That they were going to see their mother.
Okay. And was there anybody else with you and the boys when they learned?
No, ma'am. It was just me and the two boys.
Okay. And did they know that they were going to that visit prior to coming to you that day?
I do not know that to be sure.
No other questions, Jeff?
Redirect.
I don't want to get into the details, but besides convenience, there were specific reasons those children got moved, correct?
There were some safety issues, yes.
Okay. I have no further questions.
Thank you, Ms. Steptoe.
Thank you.
Ms. Carnes, do you wish to call the other witnesses?
I have no further witnesses.
And the victim impact statement which you have offered, the court has received and I have reviewed. That is, are you asking that be read?
Yes.
As well, if that is what you want to do, before I turn it over to the defense for presenting evidence and mitigation, and in as much as this would not be subject to any cross-examination, if you wish to have that read, now is the time.
Okay, yes. And what Ms. Promas ended up deciding, she would like to have Erica Glass read that on her behalf.
She may do so. Ms. Glass, come forward.
I've got two of them. You want to keep a couple of them?
And this is the original victim impact statement.
You have the signed one, correct? She has a copy.
Well, this is what is in the record.
You can switch, so you can read along.
Yeah, thank you. Record should reflect that Erica Glass has taken the witness stand, and that she does have the original victim impact statement in her hand, and you may read that aloud.
Has struggled with the thought of standing before this court, her peers, her family, her friends, her abuser, and the press once again. Therefore, I am here today to do it on her behalf. I am sharing with you her thoughts, her experiences, and her words. These are the words of God, as well as others here with her today. And we will be her voice when she needs us to be for her and for the boys. I realize today's outcome, whatever that may be, will be yet another step towards a very long healing process. Yet the thought of reliving the nightmare out loud today is too much to bear. Austin has already taken so much from me, and I refuse to allow him to take another ounce of my peace. The wounds for me and my boys are still fresh and trigger very extreme emotional and deep turmoil. The impact of these crimes against my boys and me have been devastating, life-changing, and are immeasurable. When I first met Austin, I was young, naive, carefree, trusting, and loved life. I was healthy, both physically and mentally. I had a wonderful relationship with my parents and sister. I had friends and enjoyed life. Like many young women my age, being in my early 20s at the time, I wanted to just be swept off my feet, fall in love, and have a family of my own. I thought I was so ready for that, and I thought I had found that all of a sudden. Austin was my Prince Charming. He wanted all the same things, and quickly. I jumped all in, head first. In a very short amount of time, everything changed, and my world crumbled. You have heard some of the emotional, mental, and physical pain my boys and I suffered, but only a mere fraction. I know today I am physically safe, yet I still wake up in terror, thinking I am back in that house of horror, isolated with no one to turn to and about to endure whatever pain he has come up with this time to satisfy his own warped desires. I wake up in fear for my life and for my children's lives, just like I did then. I was constantly in fear of my life. I had lost the person I was and had become a person who just did what was needed day to day to survive. I've learned in counseling that this changed my brain and my nervous system, and it will take years to recover. Emotionally, it will also take years to heal. I've been diagnosed with severe anxiety, depression, and PTSD. My anger, sadness, pain, shame, and guilt compete regularly to take over my thoughts. I have to think about what my children went through. Then I have to think about what other women went through. They all suffered at the hands of Austin. The other women were made to feel guilty and responsible for Austin's actions, his behavior, for the things he did to me when they found courage to leave. They were not responsible for what he did. That is what he did. He made everyone else feel like they were responsible for the things that he did. It hurts me that my family suffered, and I have to carry that guilt too. My parents and sister did not deserve that. They did not deserve the accusations and threats. It is hard to find the words to try to explain how much pain they sustained along with me. People question why I stayed and endured the pain and abuse. I have two reasons: my sons. As much as I dreamed of running away with them, I knew there was no way it was ever going to be safe for us just to do that. I didn't trust anyone to help me. At the time, the only way I knew how to keep them safe was to stay. If I left, or if Austin killed me, it scared me to think of the life and vicious cycle that would surely perpetuate with the boys. My children were isolated along with me. They rarely got to socially interact with other children. When we did meet new friends with the kids, those friendships rarely lasted. The boys rarely had play dates. They rarely went to birthday parties. They did not go to school, as I was expected to homeschool them. They did not have normal childhoods, and they were not allowed to be normal children. Everything I went through, emotionally, physically, and mentally, does not compare to the pain I feel for my two sons. I feel so much guilt and shame, but it was Austin who did this to us. And it will be a long time of therapy for all of us to overcome these struggles. I pray someday my boys will understand too. I still have physical scars to remind me of the beatings, the torture, and the brandings. I was humiliated daily, spoken to and treated as if I was nothing, or like I was a dog, as you all heard. I was forced to remain nude in my home, and over time, it was not only my body that was naked, but my entire being that felt unprotected. My left eye will forever be a bit sunken in and appear different from my right eye. I have blurry vision in it. I am unable to use my right hand as I should be able to do so, as I used to. I cannot grip things as I should. This will likely get worse with age. My signature resembles that of a child. The scars from the beatings and whippings will remain on my body forever. The branding of the R will forever remind me of this. I have tattoos that cover my body with derogatory and humiliating language, which that was his goal. He wanted to make me feel like trash. The tattoos were strategically placed in the most sensitive and intimate places most people would consider sacred. The tattoos that were forced on my face as punishment were meant to make me ugly, so that no one would ever want me, and to also hinder me from seeking and obtaining employment. They are a constant reminder that I lived a life in fear of the name that is written across my forehead. When Austin forced the tattoos on my face, he pointed out how expensive it would be to remove them and how I could never afford it. That is what Austin banked on, that I could never get out of this horror and could never move forward with my life. What Austin didn't bank on was that there were actually people who care. I didn't even know it before all of this. Now, the boys and I have an army, our own personal army of support. Although I still feel pain, physically, emotionally, and mentally, I am not allowing his demons to control me anymore. My boys are in therapy, but most importantly, they are safe. They are in school, they have friends, and recently started karate. They go to church and sing Christian music at the top of their lungs and are finally allowed to be little boys. They are surrounded by love and they are thriving. My whole family is in therapy, and we take things one day at a time. This has been a living nightmare for them too, and I wish I could change that. I too am in therapy and doing the best I can do. I am going through tattoo removal. It is excruciatingly painful, but well worth it. I will happily endure this pain. It won't be long until I look in the mirror and don't have to see his name anymore. It'll just be my face, with my head held high, because I survived this. Through this, I have built friendships that will last a lifetime. I didn't really get to have friends before this except a woman here and there that he chose to come into our lives, and they quickly ran away when they realized how abusive he was. Now I do have friends. I have bonded with the victims as well, and I have surrounded myself with women who lift me up, support me, and show me what true friendship is. All of the things he took from me, I now have back and then some. Austin, I want you to know this. You may have broken me, but I am not shattered. I am picking up the pieces, and like the Japanese practice of kintsugi, I am slowly gluing all the pieces of myself back together with gold. I will move forward with peace, happiness, and harmony in my life, and you will get to know another thing about me. Just know, though, I am going to use the horror you put me through to help other women. I will turn it into a story of triumph and beauty. I will make sure my boys know how to properly treat the women in their lives as they grow. I look back and think, how did I ever get so entangled in this? Then I remember you said this was your game. I wish I knew when I first met you that you considered this all just a game. You thought you always won this game you were playing too. Well, I am here to tell you, my life is not your game, and you did not defeat me. The boys' lives weren't your game to play either. I am still standing. I am still alive. I have found the I used to be. I am working toward forgiveness for you. Not for you so much as it is for me and the boys, so that I can be the best person I can be for myself, my boys, and my family. Because as I stated earlier, you don't get to take my peace anymore. Judge, I please ask that as you make your decision today, you take into account not just the pain and suffering my boys suffered, that I suffered, but the many other victims that I know you are aware of, some of which testified at trial. His own family members and my family members, not just the ones he physically harmed, but all of them have been victims in one way or another. The web of harm spreads beyond all his victims to their loved ones as well. I'm not asking you to punish him with a life sentence out of revenge or hatred. I am asking for you to spare any other human being from being put through hell by him the way he did to me, the boys, and all of the other victims.
You may step down. Record should reflect that once again been handed the original victim impact statement, and that will be maintained in the record and in the file. Anything further on the part of the people with respect to evidence and aggravation of victim impact statements?
No, Judge.
Ms. Schnock, is there any evidence in mitigation?
No, Your Honor. Sorry.
Okay, would like to as note though, as a part of the PSI, there were 3 character reference letters, and I have reviewed those, and those were tendered on behalf of the defendant. Ms. Carnes, you may argue.
Thank you, Judge. I just want to remind the court and the parties here, actually, at trial, the court obviously heard a lot of evidence, and you saw a lot of the defendant's own words through the hard work of some ISP investigators who usually deal with Medicare or Medicaid fraud and have never dealt with a case like this before, going through those Pathfinder reports. And obviously there's so much to that, but over and over again, one statement that just almost floored me when I saw it was always that when Austin said in January 2024, "Never try to play me in a game I created as a kid and expect me to lose as an adult." The words he said after he had finally gotten her to give in or to that horrible face tattoo, and then proceeds to give her 2 other derogatory tattoos, one of which says "come for," and another that says "come, C-U-M, inside." And he's telling her this is his game. It's a game of lies, a game of manipulation, a game of getting whatever he wants, doing whatever he wants to get what he wants. And it escalated over the years. I wanted to point out, even though it's not even that important maybe, given the significance of the evidence you've heard, the significance of the mandatory sentence and sentencing ranges. So when you look at the social history, it's almost like, okay, he said he graduated high school from Pleasant Hill in 2013. When the truth is, he dropped out and he got a GED. Why not just tell the truth? Why would someone lie about that? No one here cares if you got a GED instead of graduating high school. And it's an easily provable fact. And he even admitted in his evaluation in 2015 he had dropped out of high school. That's the type of person we're dealing with. When he decides to make up a lie, it's going to be his lie, and it's a lie, and then it's going to be his truth. And it doesn't matter if you can prove he is wrong. It's now his truth, and he's going to try to make everyone else believe it's true too. And it's, when I started reading this, talking about his family, the part about his mom, who basically tries to make her sound horrible, she wasn't. On page 3 of his family background, or the evaluation, he talks about his family background and childhood. He talks about living back and forth between his mother and father's home. Here it makes it sound like he pretty much lived with his dad and was abandoned by his mom. She actually went and bought the custody for him and got it in the early 2000s. He said his dad remarried Heather Rodhouse when he was 13. I know they got married in 2003. He was 10. And it's just, some of that's just misinformation. He refers to the last line of that on the PSI side of it, how he has a good relationship with his father, Heather, and Hannah. And then if you look at page 3 of this evaluation, the very last paragraph, Mr. Rodhouse described Heather as very abusive, accusing her of calling him fat, lazy, and worthless. He even stated that on one occasion, Heather spit in his face. Maybe the relationship got better, I don't know. But this is how he viewed her back then. He goes on to accuse her of stealing his medicines. And there's some other stuff in there. The next paragraph, he talks about how close he is to all of his siblings except for Autumn and Nippy. If you turn the page in his evaluation from 2015, page 4, second paragraph, Mr. Rodhouse denies a close relationship to any of his 7 siblings. He reports that his biological sisters do not like him because I stick up for my family. So at that point, don't have a relationship with any of them. Now they're all great, except for Autumn and Nikki. Autumn and Nikki told what happened to them when they were children. He wants you to think Autumn and Nikki have been arrested. I'm not aware of that. I do know they have 0 criminal history. His dad had a DUI. Without supervision. Not a big deal, but when you're supposed to write down what your families that you're aware of, probably should have been aware of that. It was 2016, it wasn't that long ago. His sisters used to have a relationship with their father until this case came along. And there's been a lot of family drama. If you didn't hear it very well, his grandma in that interview said, Autumn and Austin, we do not take anything they say as real. Nothing. Both make things up, both exaggerate things. And I want to be clear, as to Autumn, I don't believe that. Autumn's had her faults throughout life. I'm not going to deny that. But as this case has gone on, that girl is the scapegoat in this family. And he's the golden child. But to say in June of 2024 that she can't believe anything he says, nothing's real, we know it's not real, it's exaggerated or made up. And then to put a letter, reference in here, talking about he has demonstrated unwavering integrity, compassion, which I think the criminal offenses in this case, which he's been found guilty of, show that there is a huge lack of compassion. It says he's always been a person of high moral character. Which again, the offenses would prove otherwise. He displays honesty and truthfulness. I know ultimately it's a letter, it says grandma, she loves him, but you can't say one thing in June and then submit a letter to this court and try to tell this court this is an honest person sitting over here that you're about to sentence. Because it's not. Again, he tells you he graduated high school in Pleasantville in 2013. He technically was supposed to graduate in 2012. He dropped out. He did go on to get his GED. He had done, I believe Gerard referred to it as the ROTC program. I'm not sure it's the ROTC. There's a split op program the Army Reserves has, where after your junior year of high school, you go and do your basic training. You go back, you finish your senior year, you graduate, and then you come back after that and you do your AIT, which is your advanced, the AIT is the advanced training, where they're going to figure out what your MOS, military occupation specialty, is going to be. And because he dropped out of high school, he couldn't go back and do that. But if you look in what he says here on page 7 of his PSI, and then also page 6, at the bottom of that evaluation, 2015, in both of these, he has told the person who's doing the report that he was enlisted in the Army. In the 2015 report, he says he enlisted in the U.S. Army in 2012 to the present, which at that time was February 2015 when he did this. He told that evaluator that he was getting a discharge of an Article 15, which is a failure to adapt. And he said he was getting it because of that charge, and that they were just giving it to him as a failure to adapt because they knew him well enough to know he wouldn't actually do this, what he was accused of. Then you come over to what he says here. It's now, he was in Army Reserves from 2013 to 2016, and was given an Article 16, which is when they get released for not being able to physically accomplish their physical requirements. I actually did an internship with the Army JAG when I was in law school. If you get an offense, first of all, that was charged as a sexual abuse, it probably would have started the court-martial process right away. And ultimately, in 2015 March, he pled guilty to a battery, and the wording was by putting his penis in a vagina. He would have been kicked out of the Army immediately if he was actually in it. And if it wasn't a dishonorable discharge through a court-martial, it would have been a bad conduct disorder. There is no way it would have been anything less than that. And it's just blatant lie after blatant lie. And this is what he lies about background details, about his life, things you've been through. In his evaluation from 2015, he admits in there that has herpes, and he's had lots of partners. So he made sure he told all those partners he had herpes. I believe the court heard at least at one of the motion hearings about one of the victims that, not in this case that was a victim, but one of the ones that testified as a propensity getting herpes and him having lied to her about that. But if you look at his physical and mental history and condition, he doesn't report in his medical background that he has herpes. If you look at his alcohol and drug use, he also didn't report that he had a mental health treatment as a kid, and in the 2015 he reported that he went to counseling. Alcohol, drug use, that's where he says he first used in high school. So under drug and alcohol use in the 2015 evaluation, page 5. So here he says he first used in high school. In this one he says around the age of 15, which you would be in high school, but he reported that his sisters who applied one was 2 years younger and one was 3.5 years younger. They talked him into partying with them. That's the first time he had alcohol. He says once he turned 21, he started just drinking a few times a year. In the evaluation in 2015, he said he stopped drinking at age 19. And then you heard evidence where he was drinking like every single day in the summer of 2023. So we at least know he was drinking a lot as an adult too. It says he, in the PSI, first used marijuana at the age of 26. In the evaluation from 2015, it says he first used marijuana at the age of 14. And it's really hard to remember your lies sometimes, you know? So I just kind of wanted to point some of that out before we really get into the nuts and bolts here. I just really want the court and others to understand the type of human being we're dealing with. Nobody just gets to be this level of abusive to other people. It doesn't happen without something else having happened to him. And I get that. And that kind of trauma and brain development that went wrong in Austin's life had to have started almost from the get-go. When I first started this case, May 8th, I got a call from Gerard while I'm out at the Child Advocacy Center dealing with another thing, and he starts telling me about this situation, a little bit, what few details we know at this point. And I just remember thinking, this sounds this sounds bad. But in no way did I think it was going to be what it was. I had no idea how bad. And in the coming weeks, we would all start to realize just how bad this situation was, just how many victims there really were. It was interview after interview after interview. Up until the trial, we had victims coming out of the woodwork. And just never in my life have I experienced anything like this case. I've never seen this in real life. Hope I never do again. And for every one of us that's worked on this case, it's taken an emotional toll on our lives, and we aren't the victims. So I can't imagine what life has been like for the victims. I watched the jurors' face during the trial and saw the toll it was taking on them. And they aren't the victims. I can see how much this case has impacted Austin's family, his entire family. The ones who are the victims and the ones who aren't victims and the ones who stand by his side. It has taken a huge toll on them too. And while I think some of those people contributed to how he turned out and continue to enable his behavior, like his grandma who says he's truthful even though in June she said he's not, it doesn't negate the fact that his actions have a widespread effect on everyone in his life. I think he has victimized every single person in his life. His grandfather had even said, there's not a person in the family he has not backstabbed. And we have a trail of victims going back to his childhood. We have 4 known victims who were juveniles when he was a juvenile. Some of them deal with being scapegoats and being called liars. Even the youngest victim has had to deal with family members questioning her memory. Wait till the phone's on the court. And has family members questioning whether her memory is really true, and that's despite the fact that she has 3 older cousins who have all been victims. We have a victim from the 2014 case, as you're aware. She was 15 at the time. He was 19. She ended up turning to drugs to deal with her trauma, as we found out during the course of this, and ended up in prison. She was released from prison and onto parole the day the jury found Austin guilty of all 19 counts. And you've heard from many other females who had been in a dating relationship with the defendant, and he used the same MO to start beating them down mentally from the beginning of the relationship to get them into compliance, just like he did Chloe. And with them, he would go far past the boundaries they had set when it came to their sexual relationship, and he made it clear their boundaries didn't matter, that he could just do what he wanted. They could take what he wanted when he wanted it. They have spent years dealing with their own trauma because of his actions and their own guilt because they thought they're responsible. They blamed themselves and never thought anyone could believe them or that they were a victim until they met us. Today you're going to hand down a sentence on Austin for just some of the crimes he has perpetuated against his wife and children. And these sentences, I feel like, are also for those other women, because they deserve justice too. This man that sits before you is a serial rapist. Again, he said, never try to play me at a game I created as a kid and expect me to lose as an adult. Those are some of, I think that was one of the truest moments when he wrote that for him. Like, that's who he is. It's just a game. The rest of us know this isn't a game. He just wants to control everything and everyone around him. And he has, I don't know how to describe it, an insane sexual need that is fueled by hurting other people, causing pain, causing shame, degrading them, and including his own children. I said, you can watch how it progressed over the years. And then you met. The first time I ever interacted with Chloe was over a Zoom when we had juvenile court, and she was in the hospital. She was in her bed. It was clear she was weak. She could barely get words out. And after the court hearing was done, I spoke with her and her parents and her attorney for a few minutes. Her parents asked me some questions. I wasn't even able to talk at this point. And her parents were upset. They were upset with the situation. They were upset with the system. They were upset with me. And to say it was awkward would be an understatement. And across as very meek at that time. During the following weeks, there were interviews of family members of Austin. And there was a common theme we kept hearing about those who knew family members, and also Dawn Shoemaker and Katie Reisman, some other girls that knew her. When everyone at first, well, the family members in particular who had known her for years, but when they had first met her, they described her as sweet, talkative, outgoing, and bubbly. And then they all said they watched her disappear before their eyes. I remember Austin's mom one time telling me it was like she wasn't there anymore and that she was nothing but a shell. The next time I saw the person was on May 22nd. And of course, she had some trust issues with me. But Eric and Jordan were also there, and by that point, she trusted them. And overall, the interaction went well. Chloe was able to talk, but she was very serious, very matter of fact. You didn't see a lot of emotion. I don't remember her smiling much. Almost like I think she was still that person in a shell who's just trying to get the words out but not feel anything. I remember her telling me how she was going to see the boys very soon and she was nervous. I remember telling her, it's going to be okay. The people there will help you. They ask questions that are awkward or whatever. And I reminded her that they hadn't seen her in a while and they really needed to know their mom was okay. Obviously later found out, I went, well, and then I found out, I asked if someone had saved his mommy. Next time I saw her about a month later in June, in person, and by that point it was like seeing a whole new person. She looked healthy, she looked happy. There was that personality shining through that people had described. And over the weeks and months to come, we really had to start getting ready for trial, and working on the additional charges, and then very quickly get ready for trial. So we interacted over the phone quite a bit, and I really got to know her. And the person I see today is not who she was when she came out of that house in May. The person the defense would want you to believe and how they describe her in closing arguments is not at all who she is. Unbeknownst to Chloe, when she first met Austin, fell in love with him, and started down that path, she had no idea the real person he was. He used his good characteristics, which he does have, to win her over. He can be charming and charismatic, and as many have said in his interviews, he can talk anyone into anything. Actually, one of the nicest things I ever heard about him from any of the people came from his dad in regards to his ability to talk to people and his intelligence, actually. He said, if Austin had used these skills he has for good, he could have been president of the United States. But Austin chose to go the other way. I had no idea what she was getting herself into, and very quickly became a victim of mental abuse. She lost herself along the way, lost all her confidence and self-worth, and like many other victims of domestic violence, she began believing everything he told her about herself, and she became codependent. He is truly the most manipulative person I've ever encountered in my life, so it's not hard to believe he found a person at some point that he was able to get complete control of her. Austin is not your everyday run-of-the-mill domestic abuser. When it comes down to it, Austin is the one person responsible for all these crimes, and that's why he's the one sitting here before you today. He continues to refuse to accept responsibility for his actions, and as he has his whole life, it's always someone else's fault. Even with his own words from the Pathfinder reports, he thinks he's never done anything wrong. I think his words speak for themselves. They tell you the sort of person he is. And I believe the world will be a truly safer place with him locked up. In regards to factors in aggravation, the main one that sticks out to me is the first one. The conduct caused or threatened serious harm. That was a lot of serious harm.
Ms. Carter, before you proceed on, I will note that which is elements of the offense, I cannot weight that doubly against the defendant for sentencing purposes.
Oh, you're right.
So, I don't.
And I'm not going to...
As to that particular factor in aggravation, that is not weighted. That is an element of several of these offenses.
And honestly, I'm not going into the rest of... I mean, the factors that really stand out, his conduct, what the harm it caused, the impact it's had on the victims, a history of prior delinquency or criminal activity. I realize he's got one prior case, but you also heard from victims who testified at trial about other criminal offenses he's committed that were not charged. I'm never really sure what to do with the sentences necessary to deter others. I don't really see this as one a lot of other people do. I hope that no one else would ever want to do this. He held a position of trust or supervision as a family member to at least the charges involving the boys. So those are just the ones that stand out. But I think when it comes down to it, the factual basis of this case is what really stands out in aggravation. To me, it's almost like the entire case is aggravating. Obviously, with the first four counts, or not the first four, the four predatory criminal sexual assaults, he was put on notice when you have two or more victims, and he was found guilty with two or more victims. That is the natural life sentence to the Department of Corrections. That is to be served at 100% for his whole life, no parole. I would ask the court to impose that. I'm not sure I would anyway, but yeah, that's me. In regards, I went ahead and put the MSR that goes with those, which is 3 to life. Next on the list, I put in the 2 child porn cases, counts 17 and 18. I would ask, and those are mandatory consecutive to each other, I would ask for the maximum on those of 30 years, ran consecutive to each other for a total of 60 years, and for that to be ran, obviously, concurrent to the natural life. Those are to be served at 50%. MSR is 3 to life. Those also have a mandatory $2,000 fine at a minimum, and I wouldn't ask for more than that on those. I think those are appropriate given the facts of this case. Moving on to the 3 aggravated criminal sexual assaults with a range of 6 to 30 years. And I also want to kind of throw the criminal sexual assault in there with a range of 4 to 15 years. Which, if I remember correctly, they're all mandatory consecutive, but I also believe we cannot go over the 60 years on those added up together. So, what I had written down, I think on all 4 of those counts, if you did 15 years and ran them all consecutive, you would get to 60. And so consecutive with each other, but then concurrent to everything else. On the aggravated battery with torture, where he put her finger in a vise and also used his hands until he got her finger into the shape of an L. I would ask for the 15 years max on that. I realize that would be concurrent with the others. That's also a 1-year MSR. On the following aggravated domestic batteries, which are class 2 felonies, 3 to 7 years. For the spleen, the strangulation, and the disfigurement, which was one of the tattoos. Mandatory on range 3 to 7. I would ask on those that it be 7 plus 7 plus 7 for 21 consecutive, but also concurrent to the rest. Those are 4-year MSRs. On the 3 indecent solicitations of an adult, I would ask for the same thing. The max is 7. I would ask for the 7 plus 7 plus 7 for 21, and then run it concurrent to the others.
Before we go on, those would be discretionary consecutive, not.
Oh, yes. All of the rest of these are discretionary on whether, and you would have to make a finding, I guess, that it's in the public's best interest, which I would think you could make based on the factual basis. And then finally, on the aggravated battery of the children for the shocking the boys with the cattle prod, with the max being 5 on those, I would ask again discretionary, consecutive 5 plus 5, and then ran concurrent to the rest. And those are the 6 months MSR. We just have to make sure we put those in correctly. Judge, he does have that 260 days credit. I realize when he was arrested on count 1. I would prefer to make everything easy and give him credit on all the counts, even though some of them were filed later. Then when you take that 260 days, also gets $30 a day credit. That comes to $7,800, which can be credited towards fines. He does have the mandatory $2,000 and $2,000 on the child porn. And then as far as the rest of the fines go, I mean, he's going to spend his life in prison unless something were to happen down the road. So I'm not really, I don't know if I have much of a viewpoint on that other than, I wouldn't want people to think you don't get fined for stuff like this, I guess, but I also think that the jail sentence or a prison sentence is more significant and appropriate. And then just to throw in so the court's aware of the mandatory court cost assessments that are required. For the criminal assessment for a felony sex offense, which would be the highest offense for this case, it would be $1,314. Under conditional assessments, there is a $500 assessment for each conviction of a child pornography case, so that would be counts 17 and 18. He's never had a felony offense, so he would have a 250 DNA analysis. And then there is a $200 conditional assessment for every offense that is a DV against family members. And I count that as 6 because even when it's filed as an AGBAT, and it doesn't say domestic battery, my reading of that is if it is a family member, it still counts. So I had it counts 1, 25, 26, 27, 33, and 41. That'd be like 200 times the 6 counts. And Judge, that is what the state is requesting.
As to the monetary credit for purposes of fines, when that provision came into effect, I believe that was only for what was then characterized as Category D offenses. Is that? I believe that's. For these offenses, I don't believe that is $30 per day credit is applicable.
Where's our cheat sheet on it? I'll look at that if you want. Well,
before we go over, I want to have some clarity on this.
That's when I got $30 a day. I would have to look it up, Judge.
let me know.
Okay.
Ms. Schnock, you may argue.
Thank you, Your Honor. May it please the court and counsel. I do want to thank the probation office for their efforts in preparing the pre-sentence investigation report for today's purposes. They always do a wonderful job with that. Your Honor, unfortunately for Austin, our lawmakers in Springfield have done a majority of the work today by way of their mandatory sentencing laws. I wish it wasn't that way, but that's just the way it is. His fate was predetermined by the legislature before we stepped into this courtroom today, long before we stepped into this courtroom today. I would like to think that there are things that I could stand up and say today that would make that different, but it's not going to change the outcome here because you are stuck with the law that the people in Springfield wrote, and the people in Springfield think that people in this position should go to prison for the rest of their natural life. And so that's where he is going to be headed. On the balance of the counts, Your Honor, I do want you to at least listen to Rick Rodhouse's prayer that you consider the positive things that he's done prior to these events, that you consider his past contributions to his family and society. You can consider the fact that he was always a hard worker and a good worker that provided. He was working 12-hour days, 7 days a week. That was in the PSI. That was presented as evidence, and that's something that Ms. Carnes said today. Mr. Rodhouse is a very hard worker. He's always prided himself on being a hard worker, whether that is running a construction business or a tree trimming business or working on the pipeline. He has always provided, and that is something that the court can consider and cannot ignore. Your Honor can take into consideration the letter that Heather Rodhouse sent, indicating that Austin has always been a great brother to my 4 children, that he has given the 2 boys, he has shown up to their activities and events, he's provided them support, and he's always been a loving brother to them. That's Heather Rodhouse. Those were her words on Tuesday, January 7th of 2025, and there was evidence presented during trial that Austin was in town from Ohio for the very specific reason of visiting his brothers and seeing his brothers play at a football game. The court can consider the fact that Austin has very, very, very little and insignificant criminal history. Ms. Carnes wants to make a production about the other victims that testified in this matter, and they were not charged, and those have not been charged. And as we sit here today, Austin is not a frequent flyer in the criminal realm. He is not somebody that has been on and off of probation, in and out of jail, in and out of Department of Corrections. He is not somebody that has been indicated for child abuse or neglect outside of this case. He isn't the type of person that has made a life of criminality and making it a habit of coming into this courtroom and causing problems for the judicial system. In fact, he's always been one to help others in providing a meal where a meal was needed, or a place to sleep when a place to sleep was needed, or giving somebody a job when a job was needed, and that was expressed by way of the letters that were provided by Heather, Rick, and Julie. And so while the lawmakers have predetermined Austin's fate, I would respect that the court at least listen and take into consideration the words of Rick Rodhouse in his letter to the court, that he believes that his, meaning Austin's, positive qualities and past contributions to the community demonstrate that he has the potential for rehabilitation and redemption. And today, Your Honor, I would kindly ask that Austin be given a shot at redemption. Thank you.
Last line of argument, if you wish, Ms. Carter.
Judge, I believe I've said what I have to say. I think the evidence in this case has been overwhelming. To the contrary of what the letters of recommendation state, I understand how his grandparents must feel. I love him, of course. This is their grandson. I wanted they wanted to write something like that, but I also don't necessarily, in particular, one of the letters, feel it's accurate. And even Mr. Rodhouse's letter, I felt there were some things in there that were probably not quite accurate, but I can understand his prayer to the court, because that's how the grandfather would feel. You also heard what Mr. Rodhouse had to say about her at one point, which was not true. I've heard a lot of things about stuff he did to her during that time frame. But Heather loves her kids, and she'll do whatever she needs to do to make them feel loved. And I know that probably from her point of view, writing that letter was more beneficial for her children than Austin. And Judge, I think that based on the evidence you've heard in this case and everything you've heard here today, that I would ask that you make the findings and sentence that I've asked for. Thank you.
Mr. Rodhouse, you have at this time the opportunity, should you wish, to make what is called a statement and allocution. If you do make a statement, you would not be subject to cross-examination. You are not required to make any statement at this time, but if you do wish to make a statement of allocution before the court pronounces sentence, you do have that opportunity. Do you wish to make any statement, sir?
Yes, Your Honor. I can't say I had the opportunity to put anything together because I don't really know how any of this works. And I'd say that both the prosecution and my attorney has both made a good argument. Ms. Carnes mentioned earlier that it's hard to forget a lie, and I would have to agree, especially in this case, on the original police statements. I was under the impression that this had happened more than 5 times, and I was accused of holding her down and forcing her to do it with force. And when it came to trial, it turned out that she'd only done this once or twice, and I was not even present at the time it happened. Whatever sentence you decide to impose is fine with me. I've had so much relief knowing that my sons have not been assaulted that many times with all the horrors that I actually imagined could have happened or would have happened from the rumors that were going around with the limited knowledge that I had daily. I have no other comments regarding the majority of the misdirection, misinformation, or perjury that was throughout this case, and I'd like to thank my attorney, Casey Schnapp, for bringing forward everything she can and having the argument she has for the devil's advocate. And whatever you decide, Your Honor, whatever's fine in your conscience, I understand.
The court has now taken into account the evidence that was adduced at trial in this matter. I have considered the pre-sentence investigation report, its contents, its attachments. I have considered the arguments of counsel. I have considered the victim impact statement, which has been read into the record here today. I have considered the statement and allocution of the defendant. I have taken into account the statutory factors of mitigation and aggravation that the court is obligated to consider. Furthermore, I have taken into account the mandatory sentencing guidelines. Specifically, the defendant was found guilty of the offenses of predatory criminal sexual assault of a child in counts 4, 5, 6, and 10. And whereas these acts were perpetrated upon 2 different children, the law does require a sentence of natural life imprisonment on each of these 4 counts. In this matter, in light of the evidence before me, I am convinced that it's not just what is required by law, but it's what is required by justice in this matter. As to the remainder of the counts where I have any degree of discretion in imposing sentence, I have taken into account the age, health, condition, character of the defendant, as well as his criminal history that is reflected in the pre-sentence investigation report. I have also taken into account the nature and circumstances of these crimes and the evidence that was presented at trial. I do give great weight to the long-range human cost that is associated with these crimes, specifically the defendant perpetrating such severe abuse upon his former wife and 2 small children. I do suspect that this is something that they may well struggle to cope with for the rest of their lives, and that the damage done by you, Mr. Rodhouse, to them is immeasurable. I am convinced that none of this whole situation, or that the crimes that were perpetrated against Ms. Cromas, and your children, that none of this would have happened specifically as to that and the acts that were directed at your children, that wouldn't have happened but for you and your actions. And I find further that your acts were indicative of wanton cruelty on your part. In imposing the sentence here today, I can say that the evidence that has been presented and that was set forth at trial is the worst scenario that I have ever been confronted with in a courtroom. And that's over 10 years on the bench and 20 years working in the criminal courts aggregate. The sentence, other than the life sentences that are required by law, and the penalties for your crimes, in my mind, should be significant and the consequences severe, so as to have the effect of deterring anyone from engaging in similar conduct, to protect the public, and ultimately to accomplish the ends of justice. It is therefore the judgment of the court and the sentence of the court. You are sentenced as follows. As to count 4, the charge of predatory criminal sexual assault of a child, you're sentenced to natural life imprisonment with a mandatory supervised release term that I'm obligated to have reflected in this order, 3 years to life, that will be served at 100% term of service. As to count 5, the charge of predatory criminal sexual assault, you're sentenced to natural life imprisonment, 3 years to life, mandatory supervised release, served at 100% term of service. As to the charge of predatory criminal sexual assault in count 6, you're sentenced to natural life imprisonment, 3 years to life, mandatory supervised release. That will be served at 100% term of service. As to count 10, the charge of predatory criminal sexual assault, sentenced to natural life imprisonment, 3 years to life, mandatory supervised release, served at 100% term of services. 100% term of service. Those sentences will be served concurrently. As to the charge of child pornography in count 17, the court is imposing a sentence and agreeing with the state's recommendation. You are hereby sentenced to 30 years imprisonment in the Department of Corrections, 3 years to life mandatory supervised release, served at a 50% term of service, for which you would be eligible for day-for-day good time credit on that particular charge. You are fined $2,000 as required by statute. Count 18, for the offense of child pornography, you're sentenced to serve a term of imprisonment in the Department of Corrections, 30 years, 3 years to life mandatory supervised release, for which you would be eligible for day-for-day good time credit. The sentences imposed in counts 17 and 18 will be served consecutively as required by law. They will run concurrently with the remaining counts. Count 45, charge of aggravated criminal sexual assault. The court is likewise agreeing with the recommendation of the state, and you will be sentenced to 15 years imprisonment in the Department of Corrections, 3 years to life mandatory supervised release. That will be served at a rate of 85% term of service. As to count 46, the charge of aggravated criminal sexual assault, sentenced to 15 years in the Department of Corrections, 3 years to life mandatory supervised release, served at an 85% term of service. As to the charge of aggravated criminal sexual assault, count 47, sentenced to 15 years in the Department of Corrections, 3 years to life mandatory supervised release, served at an 85% term of service. Charge of criminal sexual assault, count 2, you'll be sentenced to 15 years in the Department of Corrections, 3 years to life mandatory supervised release, 85% term of service. Those sentences will be served consecutively as required by law, but will likewise run the sentences imposed on the remaining counts will run concurrent with those sentences just imposed. As to the charge of aggravated battery involving torture, count 41, you're sentenced to a term of 15 years imprisonment in the Department of Corrections, 1 year mandatory supervised release, served at a 50% rate or term of service, for which you would be eligible for for day good time credit. So the charge of aggravated domestic battery, count 1, sentence to 7 years in the Department of Corrections, 4 years mandatory supervised release, served at a rate of 85% term of service. Count 27, charge of aggravated domestic battery, sentence to 7 years in the Department of Corrections. That will be served at a rate of 85% term of service, 4-year mandatory supervised release term. Let's do count 33, the charge of aggravated domestic battery, sentence to 7 years in the Department of Corrections, 4 years mandatory supervised release. That will be served at 85% term of service. Count 14, indecent solicitation of an adult. Since the 7 years in the Department of Corrections, 1 year mandatory supervised release. You will be eligible for day good time credit on that particular charge. Count 15, indecent solicitation of an adult. Since the 7 years in the Department of Corrections, 1 year mandatory supervised release. You will be eligible for day good time credit on that charge. Count 16, the charge of indecent solicitation of an adult. Since the 7 years in the Department of Corrections, 1 year mandatory supervised release, served at a 50% term of service, and the day good time credit would apply to that sentence. Charge of aggravated battery to a child, count 25. Since the 5 years in the Department of Corrections, 6 months mandatory supervised release. You will be eligible for day good time credit on that count. Charge of aggravated battery to a child, count 26. Sentence to 5 years in the Department of Corrections, 6 months mandatory supervised release. You will be eligible for day good time credit. As to the sentences just imposed with respect to counts 41, 1, 27, 33, 14, 15, 16, 25, and 26, those sentences will be served concurrently and concurrent with the sentences imposed on the remaining counts. You will have 260 days credit for time served in pre-sentence detention dated from May the 8th, 2024 up until today, or January 22nd, 2025. I have assessed the statutory fines in counts 17 and 18 in the sum of $2,000 each. Court is assessing and levying criminal assessments as required by statute in the sum of $1,314. Conditional assessments, $500 each for the charges of child pornography in counts 17 and 18. And will likewise assess a conditional assessment for those offenses involving domestic abuse and domestic violence against family or household members in counts 1, 25, 26, 27, 33, and 41. I believe there will likewise be a $250 DNA assessment. Ms. Barnes, do you have any questions as to the sentence the court has just imposed?
Not yet. Judge, I do have that statute pulled up
Yes.
that we were talking about.
Yes.
And it says, any person denied pretrial release and against whom a fine is levied on conviction of the offense shall be automatically credited 30 for each day so incarcerated. And the only exception, it says in the next paragraph, is subsection A does not apply to a person incarcerated for the offense of sexual assault, but as defined in paragraph 1 of subsection A 5-9-1.7, which is not how I charged it.
Right, so you believe
So he does get it, yes.
Okay. And what was the sum on that? I do not have a calculator.
7,800. And I'm sorry, did you say what the fine was on everything else?
It would be it's 75. I did not actually. You're correct.
Okay.
$75 is the minimum fine, and that is going to be assessed on each of the remaining counts.
Okay.
Other than the child pornography. And so we've, to correct what I indicated earlier, whereas the law right now, Mr. Rodhouse will be given the monetary credit for time served in pre-sentence detention at a rate of $30 per day, $7,800. Any other questions in regards to the court sentence, Ms. Carnes?
No, I'll get it written out. It might take me a little bit.
That's fine. Ms. Schnock, do you have any questions in regards to the court sentence?
No, Your Honor.
Okay. Upon entry of the judgment order sentence to the Department of Corrections, Mr. Rodhouse, you will be remanded back to the custody of the Pike County Sheriff and transported to the Department of Corrections to begin serving your sentence. I am prepared at this time to make the admonitions as right to appeal. Ms. Carnes, if you need additional time to draft the order, present that to Ms. Schnock for a review, and subsequently present that for my signature. I can give you that time, but do you want me to go ahead and do the admonitions of appeal rights?
Yeah, you can start. That would be good.
Very good. Mr. Rodhouse, at this point, you do have a right to appeal the finding of guilty and the sentence that has been imposed. The right to appeal the judgment of conviction, excluding the sentence imposed or modified, will be preserved only if a notice of appeal is filed in the trial court within 30 days from the date the sentence is imposed, that being 30 days from today. If you desire to challenge the sentence or any aspect of the sentencing hearing, you must file prior to an appeal and within 30 days of today a written motion asking the trial court to reconsider the sentence imposed or to consider any challenges to the sentencing hearing, setting forth in the motion all issues or claims of error regarding the sentence imposed or the sentencing hearing. If you are indigent, a copy of the transcript of the trial and the sentencing hearing will be provided, and an attorney will be appointed to assist you in the appeal or the motion to reconsider sentence. You also have the right to ask the clerk of this court to prepare and file a notice of that appeal. You must set forth in your motion all issues or claims of error regarding the sentence imposed or the sentencing hearing. Any issue or claim of error regarding the sentence imposed or the sentencing hearing not raised in the written motion shall be deemed waived. An appeal must be filed within 30 days of sentencing, or if a motion to reconsider sentence has been filed and denied within 30 days of the date of the denial of the motion, or you will lose your right to appeal. If it is your desire to file a motion to reconsider the sentence, do not file a notice of appeal until after that motion has been decided. Under Supreme Court Rule 606, if a timely motion to reconsider is filed, any notice of appeal filed before or after that motion will be stricken, and those are your appeal rights. On that point, Ms. Schnock, is there anything you want me to do today?
Yes, Your Honor, I would request that Your Honor find Mr. Rodhouse indigent and refer this matter to the Appellate Defender's Office for institution of the appellate proceeding, Your Honor.
And with that, do you want me to direct the clerk to go ahead and file the notice of appeal today?
Yes, I would, Your Honor.
All right.
Thank you.
Clerk will be so directed to prepare and file a notice of appeal. The Office of the Appellate Defender is appointed to represent the defendant on appeal, as I do determine him to be a indigent person and entitled to such representation on appeal. Clerk will impound my copy of the pre-sentence investigation report. I'm handing you back the file, and the evaluation is contained in 14 CF 17. I would ask that my notes be impounded.
I'm really hoping this is going to be able to happen in the next 262 minutes. The one that's going to take me a while is probably the order of sentence. I got the DOC one ready. In case you want to look that one. I'm sorry. I should have done that. Where did it? Okay.
Yes, ma'am.
No, that one's done. Yeah, I'm also oh, I actually wrote these ones. This is this one. Here, do the lower version. It's 15 years. Those were all right. The only thing I haven't, oh, you didn't finish. I thought you were done. Judge, for the sake of what we typically would do, we would set a payment review just to kind of keep tabs on it. Do you want to do that, set it out maybe a year or two?
If you really want to, you may do so.
Or we can just-
circumstance. If I know it would be standard practice not to refer anything to collections in this county and to keep it on track, but if that's what you're asking me to do, I'll give you a set.
Well, what I was just thinking is, let's set it like a year out. By then, appeals should be done, and depending on what has happened with that, we may just...
Take some other course.
Yes.
All right, fine. Assume don't require defense counsel to appear in any of those matters, Ms. Schnock. That would be typical practice, and any reason I shouldn't do it.
Would the court be inclined to provide in that order that he be written after that appearance in the event that appeals are not, or maybe something happens and some other action is taken, as was just stated?
If there is anything that is to occur substantively, I will bring him back.
Okay.
Okay.
I mean,
That's all.
That would be typical practice as well. We'll see what is happening there, but I would not take any substantive action on the case, obviously without his presence.
I'm going to do January 28th or 26th at 8:30. Did I need to write an order that you're appointing, that you're finding him indigent? I don't know. I've never done that.
For that, do we not, Ms. Miller?
I've never actually done that after a trial.
We can just write up the clerk.
Yes, if you would please do that, I'd appreciate it. I felt confident there was a form to handle that situation, but if not, we will have that memorialized in general appearance order. I believe would suffice. And likewise, provide that we'll be awaiting the clerk will have the notice of appeal prepared and filed today. And if there's not going to be any impediment to that, is there, Ms. Miller?